Okay. Hello, everyone. Hola, hola. Welcome to the Culinary Business Network presented by Feed the Soul Foundation, a place where you can connect, learn, and grow all at your fingertips. I'm your host, Karina Fernandez, Program Director of Feed the Soul Foundation. First, I want to thank you for being here, not just as culinary entrepreneurs, but as leaders who care deeply about protecting your business and your team and your future. And today's session is a step-by-step I-9 compliance and ICE readiness. And I want to be very clear that this is not a fear-based training. It's actually all about being proactive and staying informed in the ever so evolving landscape of immigration enforcement. Small businesses are increasingly at risk, and especially those of you who rely on a diverse workforce. And so we know that one unfiled document or one missed form or one untrained manager can have a really big impact and consequences. And that's why this session really matters. And we also know that as things change, we want to make sure that as a foundation, you are prepared if and in case this may or may not happen to you. But we are so honored. We're joined by a powerhouse of insight, attorney Saif Ali, who will walk us through real world steps. This little toggles. Real world steps on how to complete those Form I-9s, safeguarding our kitchens, food trucks, storefronts, and even our teams. Just a little background about Saif. He is a senior associate at Monty and Ramirez LLP. He's part of the immigration division who focuses on business immigration. His practice spans through the breadth of employment and family-based immigration matters, permanent residency, and citizenship. Saif is well-versed, and that's why we invited him. He is well-versed in non-immigrant and immigrant employment-based visas, I-9 compliance for businesses. His practice also includes green card processing for employment and family-based applicants, as well as citizenship and naturalization. Saif also advises associations and companies on best I-9 compliance practices. And he is also a graduate of the University of Houston Law Center, and he received his undergraduate degree at Texas A&M University. Another Fun fact, Saif grew up in Ottawa, Canada. He's going to have to tell us a little bit about that, and is a fan of Ottawa Senators, the National Hockey League. So let's bring him up on the stage. Saif, let's get you up on here. All right. Hello, my friend.
Hey, Karina.
What an intro.
Thank you so much.
Yes, thank you for being here and, being a light in a time where, we are trying to make sense of all of these changes and how can we be, like I said, be proactive. But tell us a little bit about you, how you started, how you went into law, and then of all things, immigration law and then
Sure.
I-9 compliance.
Sure thing. So I kind of gave myself away a little bit here, but I'm actually a Canadian. Well, I am a U.S. citizen now, but I'm from Canada, and I'm an immigrant myself. And I'm a child of immigrants. My parents immigrated with me as well, and so I've been through this process, and a process that many people are undergoing. I know how scary it is. I know how uncertain it is, and you know, ever since I knew I wanted to go to law school since basically high school, and I knew that
Okay.
if I was going to go to law school, I was going to practice immigration law. Just it's a way for me to honor, you know, where I came from and give back to the same people who are going through the same thing as me. And so that's how I got into law, specifically immigration law. About Canada, and he said a little bit about Canada. Well, it's cold, so stating the obvious here. But
Yeah,
we're in
like
Houston.
Texas
Yeah,
is
we're in
great.
Houston now, where it's 90-degree summers outside. But you know, I grew up in a different temperature. Let's just put it that way.
Right. So you have thick skin. No, just kidding.
I do.
Um, all right. And so as we're, you know, navigating these new waters, right? There's nothing like a business owner being proactive and staying compliant. So we'll jump in. Let's begin. The current immigration enforcement, right? We've seen increased audits. We've seen surprise inspections. We've seen shifting of policies. Why is it especially urgent for small culinary businesses to pay attention to what's happening right now?
Right. And this is such a timely discussion. You know, I-9, and what we're going to talk about most of this, you know, is going to be I-9 compliance. And really I-9 compliance, it's not anything new under the sun. It's been the law. And there was a law passed in 1986. It was called IRCA. And essentially, this law has been mandating that employers verify the identity and work authorization of their employees for a very long time. Now, we just happen to be in a time where enforcement is one of the key priorities of the administration we live under. And, you know, and so it's vital to know and be aware of what your responsibilities are as an employer and what you need to do in order to safeguard your business and also your employees. The Trump administration has been stepping up enforcement in order to apprehend and deport as many undocumented people as possible. And so the way they do that, frankly, is not by going into each individual home, because that's not an efficient way for them to get people in large chunks at a time. But workplace inspections, workplace raids, those are effective tools for them to gather many people at one time. And essentially, the Trump administration has set kind of an informal target for deportations per day. And they're following.
And it was set like 3,000, right?
Yeah, and they're following way short of that target. And so as they're falling short, they're coming up with ways to you know, try and up those numbers and maximize and exactly. And the way they maximize, unfortunately, is by targeting employers and by targeting workplaces. And like I said, by law, you're required to verify the identity and work authorization of your employees. And so one of the main ways that you can safeguard yourself and mitigate risk is by completing the form I-9, because that's how you're supposed to record your compliance with the law. And so sometimes I have managers, and when I give this you know, conversation, when I have this conversation with businesses and associations, a lot of managers and business owners will say, well, you know, how is this my job? What's my responsibility? And it's not just, you know, if there's an ICE workplace inspection, it's not just your employees at risk. There's civil penalties and criminal penalties associated with this. And it's not just for employees, it's also for managers and owners. And everyone's liable, really, in the business. And so you are at risk if you're not complying with the law.
Yeah, and just to put this into perspective for our members, civil fines can range anywhere from $300 to $3,000 for one I-9 violation. Like, think about that. One broken window is, you know, $2,000. And some of us can't even, you know, don't have that safeguard. And so making sure that we prepare you as much as possible really is our goal, right? And so this isn't just a big business problem. It's something we really all need to prepare for. So in that, we've had conversations, you know, with our community, and we like to stay informed, but there's a missing link sometimes. I feel like we need a little bit more hand-holding in terms of those tangible skills. And that's pretty much what we're going to dive into is, what does compliance even look like? What does training my manager even look like? Well, let's break it down section by section. So help us understand the first steps, right, as a business owner, and what steps they can take right now to reduce, those ICE audits or raids. We know that raids, okay, let's be honest, this is not going to get any better. It's probably going to get a little worse. And we know that, California and LA is facing, the brunt of it right now. But it is going to go into the extension of all of our communities. And so walk us through best practices on how to prepare, right, for those regular audits, and then how to really train our staff, especially our managers, to be compliant and proactive. So tell us a little bit about that. That IRCA law, right? We'll start with I-9s, really understanding what is an I-9.
Right. So let's talk a little bit about what an I-9 is and what you need to be doing as a business owner. Essentially, if you don't have I-9s, you're probably one of the business owners that's most at risk, because not having I-9s is when Karina mentioned penalties, they range from approximately $300 to approximately $3,000. Well, the way that you limit your risk as a business owner and by maintaining compliance is by having I-9. So if you're missing an I-9 for one employee, you may get away with a smaller penalty and it'll be one violation. But if you don't have I-9s at all, then we're talking about maximum penalties, and we're talking about, liability, beyond civil liability, sometimes even criminal liability. So the first step is making sure you're doing I-9s for all your employees, right? As I mentioned, it's the law, it's part of compliance. So, we're in an enforcement heavy time, but this should be something that as a business owner, you should make part of your business practice from now till whenever. And if you're maintaining I-9s already, but you're not sure, you feel like they may be a little bit spotty, then this should help you in kind of refining the key points that you need to be addressing with your I-9s. And if you don't have I-9s, then the best time to start is now. So one of the things is, if you don't have I-9, it's best to, get in touch with an attorney. We do this for clients all the time where they haven't, or they're not aware of the I-9 regulations, and we help them set up their I-9s. Now, in this kind of situation where you don't have I-9s, but you're doing them now, you may still be, liable for minimal penalties, but you're reducing your risk, because like I said, if you have no I-9s at all, you're more at risk than anybody else. And the way you can limit your risk and mitigate that risk is by starting your I-9 practice. Even now, better late than never, frankly. And so we could probably start at the beginning. Let's talk about Section 1. And the I-9 is a form that's essentially broken down into two major sections. And the first section is Section 1. And this is called the Employee Information and Attestations section. So this section is actually filled out by the employee. And before you do anything else, if you're setting up your I-9s, if you're doing it, if you have I-9s already, but you're doing them for new hires, make sure you use the correct and most recent Form I-9. So the form is updated fairly regularly, and the best place to get the most recent Form I-9, if you're not using any kind of software, which if you're a bigger employer, you may have that. If you're doing the paper I-9s, you can get the most recent form from the U.S. Citizenship and Immigration Services website. The Section 1, like we said, is filled out by the employee. But one of the first things that I want to talk about, and probably the main trip up that happens to employers with doing I-9s, is deadlines. So like any government form, there's deadlines involved. And the deadline for Section 1, and we'll talk a little bit about it later, but there's multiple deadlines involved in the I-9 stage. So we'll talk about deadlines for Section 1, deadlines for Section 2, deadlines for Supplement B, but right now, deadlines for Section 1. Section 1 filled out by the employee, and the deadline is the end of the first day of work for pay. Sometimes I have employers tell me, what does that mean? What first day of work for pay? So the first day of work for pay means that the first day that they're, if you're in a restaurant and you've hired a new line cook, the first day they show up and they're working and they're accruing their wages, that's the first day of work for pay. Now, if you have them come in for like a pre-interview and they just happen to tour your kitchen and they're not being paid for that, that's not a first day of work for pay. Your obligations don't begin on that day. But For section 1, if they're showing up on Monday and that's their first day on the job, first day of work for pay, then the end of Monday is your deadline for completing section 1. Now,
for them to complete section 1, right?
For the employee to complete section 1.
Got it.
Exactly. And one of the things that I advise employers is that you don't have to wait till day 1, because things are hectic. You're in a moving, fluid environment. Employee shows up, you want to get them trained. There's so much that goes into day 1. And that's not something you want to leave to maybe, this could be something that we forget to complete by the end of their first day. So how early can you start section 1? Well, the employee can start section 1 after they accept a job offer. So that's the key thing. If you've offered the job, they can't complete I-9. But once you've offered the job and they've accepted it, then they can complete section 1 of form I-9. So the time frame for completion of section 1, just to reiterate, is from when the employee accepts the job offer to when the end of the first day of work for pay. And that's probably one of the most key items that I'd like for employers to kind of take away from this, is getting this deadline right is really important, because completing it late is still what we call a substantive violation.
Okay.
Although you've mitigated it, and this is when I was talking about employers who may have never filled out I-9s, you're limiting the damage that can be done to your business. You're limiting the penalties and the fines, which is better than nothing. But maintaining compliance means following this deadline. And so for any new hires that you have, making sure that they follow the employee, first day of work by the end of Monday, they're filling out section 1. It's supremely important. So that way you limit the risk that you're exposing yourself to. Now, section 1, because it's filled out by the employee, some of your employees may not speak English, or they may not be able to read or write in English. Right. So a tip that we often give to employers is that Puerto Rico has form I-9s that are issued in the Spanish language. Now, the key thing is that you have to, if the 50 states of the United States of America, you have to complete the English version of the I-9. But what you can do is give your Spanish-speaking employees a copy of the Puerto Rico I-9. And so what we tell employers, it's a great idea to laminate it, because that way the employee's not going to be tempted to fill out the Spanish version.
That's a good idea.
And that way they know it's clear. It's just a guide for them to follow along, but they still need to complete the English version of the I-9. And also, if they get assistance, if they get a preparer or translator to help them, then there's a supplement that goes along with this. It's called Supplement A, and it's important for that translator and or interpreter to prepare to sign their name on that form as well. It's just a small section where they indicate their details and they say, I helped and prepared and translate this form. But again, for Spanish-speaking employees, the Puerto Rican I-9 is a great guide. Again, we advise laminating it so that there's not a risk of them completing that one by accident, because you do need to complete the English I-9s. And the most important thing is to make sure that the employee signs and dates the day they complete section 1. So if you're completing a section, let's say you've been in business for 2 years and you weren't too aware of I-9s. One of the worst things you can do is backdate an I-9 when you didn't complete it on that day. If you're completing an I-9 now, it's important that when the employee fills out section 1, they're filling out section 1 on the date when they sign it at the very bottom. They're doing the date that the employee completes section 1 and not the date of hire, because you don't want to backdate your I-9s. You want to complete them on the day you're completing them. And remember, late is better than never.
Got it. And with the understanding that some business owners may not be doing this step, and they'll be, sending this over to like a bigger company or like an ADP. But still, I want to make sure that small business owners understand what these forms look like, understand, the importance of them, what sections get done first and who does them. And so moving on to section 2, correct? This section is, we as small business owners are responsible for this section moving forward, correct?
Correct. And like we talked about deadlines for section 1, I think probably the most important thing to talk about is deadlines for section 2. So section 2 can be completed by anybody that's an authorized representative of the employer. So anyone that, really, it's kind of a wide range. It's anybody that you designate as the owner or the manager, is somebody that you designate with the authority to complete the I-9. So typically that's an owner, a manager, or an HR representative. But again, it can be anyone that you provide that authority to. So as long as they're an authorized representative. Now, the key deadline for Section 2 is completion within 3 business days, and you're going to have to bear with me, within 3 business days after the employee's first day of employment. So if that sounds a little bit confusing to you, you got to think of it this way. Let's say the employee's first day is on Monday, right? And they show up and they complete Section 1 before the end of Monday, and that's their first day of work for pay. What's 3 business days after that first day? So Tuesday would be the first day after. Wednesday would be day 2 after, and then the third day would be Thursday. So by end of day Thursday, 3 business days after the first day, which is Monday, you need to complete Section 2. That's your deadline. Now, business days is kind of a tricky word here. So this is why, lawyers live for this. We live for the trickiness. Business days is key because if you think of in a setting where you've got a, let's say an office, right? We're only open, for example, from Monday through Friday. Basis. So for me, a business day is Monday through Friday. So if I hire somebody on a Friday, not that it's likely, but if I hire somebody on a Friday, well, then Saturday and Sunday typically aren't business days for me. But on the other hand, if you're a restaurant, chances are you're open on Saturday or you're open on Sunday, and probably even open on both, right? So in that case, what happens if you hire a new cook, let's say on Friday? Well, then Friday is the first day of work for pay. They show up on Friday and they complete Section 1. Great. They've complied with the deadline for Section 1. You've complied with it. And remember, you're on the hook. So it's great that they're complying with the Section 1 deadline. But then, okay, so what's 3 business days after? So you're open Saturday. That's business day 1. You're open Sunday. That's business day 2. And then you're open Monday. So that's business day 3. So then at the end of the 3rd business day, Monday, you've got to complete Section 2 of Form I-9. So remember, based on your business, based on your individual circumstances, this can vary. It really is based on what your business days are on a customary basis. Now, if you happen to be open maybe one Sunday in a blue moon and it's not a regular occurrence for you, but let's say you're hosting a party or you're hosting an event, a corporate event, and it's not a typical day, you've had to ask your employees to come in and cover that day for you, but generally you're not open. That's where you would not consider that a business day. But if you're just open for Sunday brunch on a regular basis, then Sunday is most likely a business day for you. And it's something you need to consider when you're thinking about deadlines.
And some, actually, I'm glad you brought that up. Some businesses are actually not open on Mondays, most restaurants that are small and independent. So then if you hire someone Friday and you're open Saturday, Sunday, then your deadline is actually Tuesday. Is that
Tuesday?
Correct?
Yeah. And like I said, it'll vary from employer to employer. So it's really important to consider your individual circumstances as a business, because there's not really a standard. It's based on what's standard for you.
Right. And then, so we covered Section 1, that's the employee. We covered Section 2, which is the responsibility of the employer or a representative of the employer. So what, and we saw, I'll put it back up again. We saw there's, there are various sections like list A, list B, list C. And, for a first timer see this, you're like, what is this? And we can talk about, let's talk about how to break those lists down and then show us some examples of what those may look like, because I know I would have questions like, how can I tell the difference? So tell us, what's the difference between list A, B, and C?
Right. So now that you know the deadlines of what you need to do on Section 2, what do you actually need to do as part of your responsibilities in Section 2? So what you're responsible for primarily in completing Section 2 is physically examining the original documents, and the key word here is original, that prove the 2 main things that the I-9 is trying to verify. And the first thing is identity, and the second thing is work authorization. So the I-9 has an attached list of documents that are valid documents that the employee can show you. Now, one of the other key factors here, and I always like to stress this, it's the employee's choice to show you whichever combination of documents, provided that they're valid, that they want to. So you cannot say, I need you to give me your driver's license and your social. Sometimes employers, and really sometimes it comes from a place of wanting to make it easier for the employee. Right. But it is ultimately the employee's right to show you whichever valid combination of documents that they want. Now, if they show you an invalid combination of documents, you don't have to accept that. In fact, you shouldn't accept it. But you can't mandate that I need you to present me with your green card, or I need you to present me with your social. It's their choice as to what they want to present. Now, they can present to you generally 2 different types of documents, and they're in 3 different lists. And what I mean by that is that the documents, a list A document proves their identity and employment authorization. So if an employee presents to you a list A document, that's all they need to present to you, because they're hitting both the elements of the I-9. They're proving their identity, and they're proving that they're authorized to work in the United States. In lieu of presenting a list A document, they can present a list B, one list B, and one list C document in combination. So we're talking 2 different, where either one list A or a list B and a list C document in combination. Now, there's a lot of documents on this list, right?
Yeah,
and one of the questions you might have is that, how do I know that these documents are real? So it's one thing to know which documents are coming to you, but how do you even know that the documents are real? And sometimes employers will ask me, well, do I need to look up the numbers that are on the document? And it's important to remember, if we can scroll up to the section 2, we can, I think, maybe show that element. But it's important that you have to record the document numbers, the dates, the expiration dates, and you have to sign and attest to it. There's a attestation at the bottom of section 2. But how do you know that those documents are even real? And sometimes people will say, hey, Saif, I don't know, an employee presented me this card, but how do I know it's real? What if it's fake? Am I liable? But you don't have to be a document expert. So the I-9 regulations don't require that you have to take a microscope out and really physically examine every single document with laser precision. But what you do have to do is look out for obvious signs of non-genuineness. So that might be something like a wrong background. Like, we generally know that Social Security cards are printed on a blue background. But if somebody gives it to you on a neon green background, that might be a tip-off that it's not a real document. If somebody
Can you say that statement again? You are not, as a business owner, you are not a
document expert. And remember, there's a lot of different documents. If you look at that list, there's a lot of different documents that could come your way. So you're not required to be a document expert. Your standard as an employer is to make sure that the document reasonably appears to be genuine, unexpired, and that it relates to the person that's showing it to you. So another, example of a sign of non-genuineness, if somebody gives you a driver's license, and let's say that the name is real, but it's got 2 people's faces in the photo. Well, that's probably a good sign. The DMV typically doesn't let you do that when you go for your driver's license. It might be a sign that that document is fake. And remember, if it reasonably appears to be genuine, if it's unexpired, and if it relates to the person that's showing it to you, then you should accept that document. Now, what if there's like a small name discrepancy, right? That's another situation we see come up a lot of times. Let's say you have an employee that fills out their name in section 1 as something. And really, of course, it's best if the section 1 name and the document and how it presents the employee's name in section 2 appears to be, exactly the same. But if let's say there's a small name discrepancy. For example, I always like to give the example. If you hire somebody, let's say named Jane Doe, and they present you with a US passport that says Jane Johnson, but the passport, you've seen remember, you're examining the original documents, right? So the passport looks legitimate. It's a thick, well-binded passport, and it's got Jane's photo on it. It looks exactly like Jane, no difference at all. But the name says Jane Johnson, and you say, "Hey, what's going on?" And Jane tells you, "Well, actually, Jane Johnson is my maiden name. I just got married 2 weeks ago, and I'm filling out paperwork with my married name now." Well, can you accept that passport? And the answer is, yeah, most likely, because as long as the document again appears to genuinely relate to Jane, it's unexpired, and there's not an obvious sign that it's fake, it reasonably appears to be genuine, then that's an acceptable document. Like in this case, it really does seem to be Jane in the photo. Everything leads to be Jane, and she's providing you with a pretty reasonable example, or a reasonable reason for why there might be a name discrepancy. Another common situation, sometimes some cultures have different surname practices. For example, the Hispanic community, we often
have long names.
Long names, and generally 2 surnames, right? So the first surname is usually the father's surname, and the second surname comes from the mom's side of the family. So if you have somebody named, for example, and I think Daniel always says Daniel Ramirez Rodriguez. And so Ramirez is his dad's name, and Rodriguez is from the mom's side of the family. Situations like that where an employee might write out their full name, but their document maybe only has their paternal last name, and it varies from culture to culture. Those kinds of name discrepancies, again, as long as the document appears to be genuine, appears to be relating to that person that's presenting it to you, and they provide you with a really reasonable reason for why the name might be a little different, and that document is unexpired, you can accept it.
So genuine, unexpired, and there was a third one, sorry.
Genuine, relating to the person.
Relating to the person.
Relating to that person, yeah.
Got it.
And so that's your standard. Remember, you don't have to run the document number through any database to make sure that it's legitimate. You just need to physically examine those documents, and you need to make sure that they're reasonably related to that person and that they're not expired, so that way you can actually accept them. And then, of course, now at the end of section 2, you're signing a certification, because remember, you're saying that you've physically examined these documents, unless there's certain employers that don't have to examine them. And we'll talk a little bit more about that in the E-Verify section. But if you're not an E-Verify employer, remember, you're physically examining these documents. And when you're signing that form, you're saying that you've examined these documents and you did exactly what I just mentioned. They reasonably appear to be related to that person, and they reasonably appear to be genuine, and you examine them. If you're not examining those documents physically, the originals, then signing that attestation can get you in trouble, because you're doing something that you haven't said that. So remember, it's key to examine those documents, and you've got a deadline. So keep that in mind. You've got a deadline by which you got to examine those documents, 3 days, 3 business days. And then you've got to make sure that you're examining the originals, and that you're examining documents that reasonably appear to relate to that person, they're unexpired, and that they're genuine. They reasonably appear to be genuine.
Perfect. And so once I've completed this section, what is next?
So once you've completed the section, congratulations, you've completed the I-9. Now, your responsibilities don't end there. I know we're excited. We're like, oh, we're finally done. Well, not really, but you've filled out the meat and potatoes of the form. And we'll talk a little bit about now, okay, how long do you need to keep these I-9s? So for any employees that you have that are current, you need to be keeping your I-9s for them throughout their tenure at your company. Now, if an employee departs or they're terminated, you need to retain the I-9 for either the later of 3 years from the date of hire or 1 year after the date of termination. So it's important. So it's the later of those two. So if you've got somebody that's been with you for a long time, they've been with you for 5 years, then most likely you need to keep them for the later of the date of termination, because it's been long since 3 days since the date of their hire. But if you have an employee that leaves you after a couple of months, then whatever is later you need to be going with. So that's important to keep in mind. It's either 3 years after the date of hire or 1 year after the date of termination.
So 3 years after the date of hire or 1 year after the date of termination.
Yeah, exactly.
Got it. And then another question is, I get this quite often, is do I keep the hard copies? Do I keep do I just digitize all of them? What is the proper protocol to have them to store them, right? Because they, some are handwritten, and some, again, let's say they go through a software program to implement these I-9s. What is best practices?
So best practice is always to keep originals. Originals is better than nothing. Okay. But if you don't have if you don't have best practice is to keep originals, digital copies are better than nothing. So it's better to have digitized versions, and sometimes it's a good idea to make sure you have both, because you're not just throwing away the originals. You keep the originals on hand, right, and you keep the digital copies. But originals are always best practice. And another point that, Karina, I know that you kind of hinted at it, but you're talking about hard copies and copies. When an employee presents documents to you, unless you're participating in E-Verify, again, we'll talk about this a little bit later, you don't typically have to actually keep copies of those documents. It's a good idea too, but you don't necessarily have to. You're not actually required. The important thing is to make sure you keep the I-9 itself.
Got it. And then I know, and we'll probably talk about this in the consecutive sections of if you are going to have these copies to make, because it does have sensitive information, where should managers or owners store these? In a locked cabinet, in, easy to access? If you do get an ICE audit, do you have to present all these I-9s to them and make sure that you're compliant?
Right. So definitely the documents should be as securely stored as possible. Like you said, there's sensitive information on them. There's social security numbers, identifying information, and those things are sensitive. And if they leak, then it can cause liability to you as an owner.
Right.
So it's a good idea to always make sure they're kept in a secure place. It'll depend for you on a situation to situation. Maybe that means a safe in your office, in the owner's office or the manager's office, or another secure location. And in case of an ICE audit or an ICE inspection, you may be required to present these I-9s. So it's a good idea to make sure that they're in a place where you can reach them, because, and we'll talk about it a little bit later, when we talk about ICE audits and ICE investigations, we're again dealing with tight deadlines. And so you want to make sure that there's some place you can access them within, same day is probably best, but at least within 24 hours, and not much later than that, because sometimes we're dealing with deadlines of 48 or 72 hours. And so accessibility is also still important.
Right. And let's go back a little bit to kind of showing our members what the appropriate documents do look like. So which one would you like to go through first? We have
let's talk a little bit about some of the common documents that we see. The first one is U.S. passport. It's a pretty common document. And
Oops.
Let's see.
I picked it. There we go.
There we go. That's it. Yeah. So, I mean, a lot of us have probably seen a U.S. passport before. Maybe we have one. And a U.S. passport, this is a List A document, because this tells you two things. It tells you, one, who that person is. So it's talking about their identity. And then it also tells you that this person is work authorized because they're a U.S. citizen. And again, if the passport appears to be genuine and relating to that person, you can accept it. And List A documents, for Section 2, that's all you need to present. You don't need to present a driver's license in combination with this, because a driver's license is, we'll talk about it, it's a List B document. List A, you've proven two things, is you've proven identity and work authorization.
Identity and work authorization.
Exactly. Another common document that you'll see is the U.S. Permanent Resident Card, or the LPR card. This is often called a green card in immigration lawyers. It's formerly known as the Form I-551. But this is another common document that you'll see, and this is the same as a passport in the sense that it's a List A document, because it's got the picture, so it's telling you who the person is. It's got their identifying information. So we've talked about identity. And the other thing is that permanent residents are essentially authorized to work anywhere in the United States. And so they've got work authorization. So you've proven the two things that a List A document is supposed to prove: identity and work authorization.
So List A, just to recap, U.S. passport, and this is what it looks like, and a U.S. LPR card, also known as a green card, and that just tells you you are authorized to work and you are a U.S. citizen.
Yeah, or rather, your identity and that you're authorized.
Your identity and you're authorized to work. Got it. Yeah. Okay.
And another common List A document is a work permit.
Got it. Work permit right here.
Okay. So you'll notice it looks a little bit similar to a green card, but it says employment authorization up at top. It's a different color. Typically, right now, when they're produced, they're this pinkish, purplish, bluish color that looks like the example that's above. And this also does the same thing. So this talks about your identity. So it's got your picture, your identifying information, and it's got work authorization. It proves that you're authorized to work because it's an employment authorization card. Now, and we'll touch on this when we talk a little bit about Supplement B, which is the last section of the form that you need to be concerned about. But work permits like these are typically not permanent documents. So if somebody presents to you a U.S. passport that's unexpired and it's valid and it's genuine, then you're good. Once you finish that I-9, the Section 2 with the passport, you don't need to ever look at their employment authorization and work authorization and their identity again. Right. That I-9 is as set in stone as you can get with I-9s. Got it. But And same thing, permanent resident cards, the green cards, they also have an expiration date. So do passports. But once you've completed an I-9 with one of these documents with US citizens and with permanent residents, you don't have to re-verify. But work permits are different.
This one here, where is the, sorry, I can't.
So you'll notice at the bottom, it will say permanent residence since, and it'll have a date. And then at the next to it on the left, it'll say card expires 10/26/32. Now, this is just a sample, but if in any time before 10/26/32, if this person presents to you a green card, then once you've filled out the I-9 and you've completed it, at that point, you don't, even if the card expires, you don't need to go back and look at it ever again. Permanent residents and citizens, and it's rare, but citizens of certain U.S. territories, which is probably a little bit too granular, but certain people are entitled to that benefit with those documents. But work permits are not, because work permits are granted typically to people who aren't citizens or permanent residents of the United States. They may have some other kind of temporary work status, like maybe they're a student worker or a temporary worker, or they're a spouse of a temporary worker or something like that. And so those statuses are not indefinite, unlike, permanent residence in the name is permanent. Citizen, again, permanent. But these are temporary statuses. And so these documents have an expiration date. And when those expiration dates come up, you'll need to re-verify. And we'll talk about that in supplement B. So, but for now,
so in this one, it says card expires 10/26/24. So as an employer, I would be like, okay, I have to go and go to section B and do the recertification.
Exactly. And the supplement B re-verification. So as an employer or as a hiring manager, one of the key things that you need to be looking out for is if you get a document that needs to be re-verified. So typically these work permits are ones that need to be re-verified. It's a good idea to note down that date and schedule reminders. Put them on your Outlook, put them on your employer, your system. Make sure that you schedule reminders 90 days out, 60 days out, 30 days out, because on the date that document expires, by then, the employee is supposed to present you with a document, and you're supposed to complete this supplement B, this re-verification section, by the date that the document expires. Got it. That's one of the key things that will, and so since we're on supplement B, let's talk a little bit about it. Supplement B can be completed for 3 different reasons, but only one is mandatory. And that mandatory reason we just talked about is re-verification of expiring documents. Got it. So the other 2 options that you can complete them is if you're rehiring somebody, and I'll talk a little bit about that. And also if your employee has a name change. Those are optional times you can use supplement B, but they're not required. The only time it's required by law is when you have a document that's expiring and you need to re-verify it. So a document in section 2, if it's expiring and it's something that's a temporary status, for example, like those work permits, you have to re-verify by the expiration, and you have to complete it on supplement B. So some documents don't expire in the sense that even though they have an expiration date, if they're on the I-9 and they were valid at the time they were presented to you, even if they expire, they don't need to be re-verified. U.S. citizens with their passports. Asylees and refugees will have certain documents that even though they expire, once they've been granted asylum, they've been granted refugee status, that you don't need to re-verify their documents. Green card holders who provide you with a green card, even though that green card, it has an expiration date, you don't need to re-verify it. And also list B documents. So once you've been presented with a list B, let's say employee gave you a list B and C combo that we talked about. If they give you a list B, you don't have to re-verify that one. You may have to re-verify the list C document if it's expiring. What is
the list C document? What's an example?
So a list B document, for example, might be a driver's license. That's a very common list B. So even though driver's licenses expire, you don't have to re-verify list B documents. And that's a state identification card. That's also a good example of a list B document. Those don't need to be, even though they have expiration dates, they typically, as long as they're valid on the date they were presented to you, they don't really need to be re-verified because your identity doesn't change in that sense, but your work authorization may change. Got it.
And then you have this other one.
And that's as long as the list B document when it was presented to you is valid and it was unexpired at that time, even though it might expire at a later date, you don't need to re-verify a list B document.
Got it.
Yeah. Now, some documents we talked about do need to be re-verified. In the restaurant industry, I imagine most of those will be work permits like we just talked about. And that's why I wanted to spend the most possible time talking about those work permits. But sometimes for employers, you might have somebody in a different, they might have a work visa and their documents might look a little bit different. They might have an I-94, for example, and those have expiration dates. Those need to be re-verified. So generally when we're talking about temporary work statuses or temporary work permits or temporary work visas, those are documents, those I-9 documents typically need to be re-verified.
Got it.
And then ones that are permanent do not need to be re-verified.
Perfect. Okay.
Yeah.
So we talked about all the supplemental documents. We've gone through every section of the I-9 that we are responsible for as business owners as well as the employees. Is there any other section that we should kind of be familiar with or understand?
So those are generally the main sections that once you've kind of familiarized yourself a little bit with the types of documents that you see and some of the documents that you might encounter. I think one thing that I did want to talk about a little bit was the List C document. This might be a situation that many of you come across. Is a really common List C document that you'll see is a Social Security card. It's probably the most common List C document of them all. If you're an employer, I imagine if you do I-9s, you've probably seen the driver's license and the social. That's a List B and a List C combo, but not all socials are good. And I wanted to kind of go over what's a good social and what's a bad social for I-9. So this, what's on the screen right now, that's a great example of a good social because this is a Social Security card. That's what we call unencumbered. It means that there's not any kind of restriction on it. Again, as long as it appears to be genuine and related to that person, that you can accept it as a valid List C document. But there are some Social Security cards that are what we call encumbered. And what they'll look like is that. And essentially they'll have some variation of the language that says valid for work only with DHS authorization. And what that means is that this social was given pursuant to some kind of work visa. Maybe, for example, that person has an H-1B visa, or they've got an H-2A visa, or I think in the restaurant industry, you might see H-2B visas more commonly. If you have those kinds of work visas, you'll get issued a Social Security number because you got to fill out tax. The employees have to fill out taxes. They have to, for paperwork purposes, but they can actually use these socials just as an identifying document. So if I'm a new hire and I show up on my first day and I complete Section 1, great, and I give you my driver's license and this social is not a valid List C document. So one thing that I wanted to touch on briefly is if somebody gives you documents that aren't valid, you need to let them know, hey, these documents aren't valid. A great thing, one thing that I advise doing is giving them a copy of the list of documents and just letting them know, hey, pick anything you want from this and just bring it to me. Remember, it's their choice what they want to do. So you can't say, hey, this social is no good. I need you to bring me X, Y, and Z document. So we want to stay away from that. What we do want to do is if a document's not valid and we can't accept it, we know we can't accept it, we give them the list and we say, hey, bring me anything from this list. As long as it's a valid combination, I can take it.
Got it. And then, okay, so just to reiterate, they can either present one document from List A, or they would have to present one document from List B and List C together.
Exactly. Yeah. So either one List A or one List B combined with one List C.
Perfect. And then we showed examples. Okay, so we talked about, how to properly fill out the I-9. The first section is the employee, the second section is the employer. What happens when, and then you have supplemental B, which is the recertification. What happens if you cannot recertify in I-9?
Right. So when we're talking about deadlines, again, if you've got an employee in Section 2 and they can't present to you work documents on time, unfortunately, if you can't continue to employ someone who can't prove their work authorization and their identity in the United States. So if you can't comply with the terms of the I-9, then unfortunately, let's say this is a Section 2 situation where it's past the third day and they can't present to you a valid combination of documents. Unfortunately, that's a situation where you have to terminate because that person person is not employable in terms of they don't have work authorization, or at least they weren't able to prove work authorization. And in the case of a re-verification, for example, if an employee has a work permit and they were, everything was fine when they initially got hired and you completed Section 2, but their work permit is expiring. And now that it's the expiration date, and unfortunately they don't have documents. The humane thing, we always want to do what's right by our employees, but in compliance with the law, is if an employee can't re-verify on time, they can't present valid documents. Unfortunately, the proper recourse is to terminate, because that person no longer can prove work authorization or status. And so, of course, these are always fluid situations. Sometimes we talk about that list A and list B and list C. It's a big list. There's a lot of documents that you maybe have never seen before. If you're unsure, if you have HR, you have legal, kick it up to the next level. Ask, find out, okay, from your attorney or from your HR representative, are these valid documents, and get the right answers. And that's why we talked about a little bit earlier. We said 90-day reminders, 60-day reminders, 30-day reminders before re-verification.
On a calendar, right?
Yeah, keep it on your calendar. Start the process a little bit early, because when you've got that deadline, you don't want to be trying to figure out things on the last day. And so when you're dealing with that kind of situation, there's a lot of uncertainty, and you want to be able to keep employing your employee. It's great to resolve that uncertainty. And then, of course, if you've tried everything and unfortunately there's just no other recourse, they can't prove work authorization beyond their expiration date, then you have to terminate. But you want to make sure you do everything that you can do as an employer, before then, to make sure that your employee at least has the time they need to do what's right for them and present their work authorization documents.
Right, and avoiding those fines, right?
Avoiding those fines, yeah. From your side, avoiding those fines, and helping your employees help themselves and make sure that they can keep proving their work authorization and identity and keep being employed with you.
Yeah. So just to recap, if they cannot produce a document that is either in list A or list B and C, then it is the best recourse is to not hire, or in the case that you do hire them, but later on during the recertification or re-verification, they cannot produce a document that says that they are allowed to work, then that recourse would be also to terminate. And
always, exactly. And always remaining mindful of those deadlines.
Right. Always, and keeping it on your calendar.
On your calendar. Yeah, exactly.
So that. So other than that, what other steps should we be taking, or what other initiatives? We talked about E-Verify, right? Mm-hmm. And how to break that down. We know that there's certain states, as you mentioned, Florida is one of those states where you do have to use E-Verify at a certain amount of employees. And then it is good practice to use E-Verify, but let's kind of break down what is E-Verify. I'm going to put it up on the screen. What is E-Verify? Should employers use E-Verify? When they should use it, how it's used, and why?
Great. Yeah. So E-Verify, I know we talked about it a little bit, completing the form I-9s, right? E-Verify is not a requirement. Unless you live in certain states do mandate that you complete E-Verify. It's a system that works in concert with the I-9. So remember, E-Verify, if you're doing E-Verify, you're not absolved from doing I-9s. If you're an E-Verify participant, you're doing I-9s and you're doing E-Verify. And what E-Verify essentially is that unless you live in a state where it's not voluntary, it's a voluntary internet-based system that compares the information that's entered by an employer from the I-9 to records that are available to the Department of Homeland Security or to the Social Security Administration. And essentially the government confirms employment eligibility for you. And then there's something called E-Verify Plus, which allows you to actually complete the I-9s directly through E-Verify. Remember, I said, if you're doing I-9s and you're doing E-Verify, you got to do both. So E-Verify Plus is another optional service, and it allows employees to complete the I-9 directly through E-Verify. So it kind of digitizes that system for you. But otherwise, if you're just an E-Verify employer, remember, you're doing the I-9s and you're doing E-Verify. And so sometimes employers will say, well, okay, should I register? And really there's two factors at play. And the first one, Karina, you touched on it. If your state requires you to do E-Verify, then that's not, you don't really have too much of an option, right? You've got to be an E-Verify employer. E-Verify is voluntary at the federal level, so it means there's not a mandatory mandate from the U.S. government that you have to participate in E-Verify, but individual states have decided to pass laws that make businesses become participants of E-Verify in their state. So, for example, South Carolina is one of those states where all employers have got to be enrolled in E-Verify. Some states are like Texas, where only state agencies, that could be even like school districts, and then contractors or subcontractors. So if you work with the state on you're helping build roads, or you're involved in state construction activities, if you have contracts with the state government, then you're required to be E-Verified. But otherwise, if you're a private employer, there's no mandate on you yet. That could change. Some states don't have any kind of state requirement at all. For example, New York, and then some states, I believe Illinois and California, actually have laws that that force employers to not mandate E-Verify, or that rather no entity can mandatory force somebody to use E-Verify. So it's almost like another layer of protection against that some states don't really want to use E-Verify, so they're going to say, hey, it shouldn't be mandatory at all, and we want to put that in law. But it's a hodgepodge, because again, so we got 50 states, we got 50 different sets of rules. So what works for somebody in Texas is maybe not what's going to work for somebody. Like you said, Florida requires, if you're a private employer and you've got more than 25 employees, you've got to be on E-Verify. Or if you're, again, like similar to Texas, if you're a state contractor, you've got to be on, or you're a public employer, you've got to be on E-Verify. So it's different from state to state. But let's say you're not in a state that forces you to use E-Verify. So should you still use it? Like with everything, there's pros and cons. One of the biggest pros is that if you've ever done E-Verify, this is a quick system. It gives you a response within minutes of submitting an E-Verify case. And you can receive an initial determination pretty quickly. It also gives you a good faith defense because you're relying on a government system. So this is it's an added layer of protection. With an I-9, you're physically examining the documents, but remember, you're not a document expert. But the government is the document expert, right? They've got databases. So when you submit all that information on the E-Verify system, you can rely on it. And if the E-Verify tells you can rely on it, then you have a good faith defense. So the employers say, well, look, I looked at the documents. They appeared legitimate to me when I completed the I-9. I put them in the system, and the system told me they were good. And then now you're coming back and saying, well, they're not good. Well, you know what? I did they looked reasonable to me. So they passed my test, the test that I'm responsible for, plus they passed the E-Verify system. So it gives you an added layer of protection. It's called a good faith defense that you can use if you're ever, audited, or you face an investigation. It's online, so, ease of access, and it's pretty simple to use. It's not overly complicated. And the E-Verify system does have, guides and lots of, different workshops on how to use it, and so it can really kind of help you with the system. Now, if you get an E-Verify mismatch like you've got on the screen, I think you're really going to lead into that, right, Karina?
I was so this is an example after. Okay, so I love what you said, and it is true. This is a layer of protection for you. It is up to you. Again, because our members are all over the country, it is up to you if you want to take that extra step, if you are not required to by your state. Okay, let's just be transparent on that one.
Right.
When you do go through this, you can have a manager or yourself go through the process of enrolling into E-Verify. It is free, and then someone asked me, well, how do I know if I did it right? Well, you'll get something like this that's on the screen, right? It says, you've submitted your, you've submitted your documentation, and then say he's going to go into what if it comes out that I need to fix something, or we could do a whole other training on just how to implement E-Verify, how to fix documents and stuff like that. And then you do have deadlines in order to fix those things. But again, it is a layer of protection for you and your business, because now you're telling the government, hey, I did all my due diligence, I did everything I was supposed to do, and look at all these confirmation pages of all of my employees, right? And then there's more steps to this, because if you do have permanent or work visa employees that do need to get recertified, then you have to go through that process again. But go ahead, Saif, explain to us a little bit more about what we have on the screen right now.
So this is a situation where you might receive what's sometimes called a tentative non-confirmation. It's a mismatch. So like we talked about, in a situation where maybe you've got documents that appear to be genuine, there are some really good fakes out there, really good fake documents that if you're just completing the I-9, and to any reasonable person, they may appear legitimate. But when the government has access to databases that you don't, and if it runs through the E-Verify system and it turns up as, hey, this document isn't valid, well, the government doesn't just send a buzzer and say, well, hey, you need to fire this person right away. That's not what they do. Typically, what will be the outcome of a let's say a negative E-Verify result is that you'll receive this non-confirmation or a further action notice. And if you receive a further action notice, it'll essentially lay out the steps that you and the employee together need to take to resolve, and they'll give you a deadline. So E-Verify does have that added benefit. So if there's a negative result, it's not like the guillotine is falling on your head. You've got some time to resolve that with the government. So because E-Verify is, even though it's a computerized system, and this is really a con of the system actually. So we talked about pros. One of the cons is that E-Verify is not foolproof. It can make mistakes. So sometimes you'll get false positives and that's where you have the good faith defense, fortunately, to kind of cover you, because you'll have a document that appears to be legitimate. E-Verify says it's legitimate, but maybe it's not. Maybe there's some kind of issue with it and it's slipped through the system, and E-Verify gave you a positive result, but it's not actually. Well, you have a good faith result, but it is still a negative, right? It slipped past you, and even though you complied with what you're required to do, which is the reasonableness test, and it also slipped past the government database. Sometimes you can also get false negatives. So in this case, you can get tentative non-confirmations for somebody whose documents are actually genuine, because even though it's a computerized system, it's not perfect. And then remember, one of the other cons, I just talked about it, but if you enroll in E-Verify, you're doing both the I-9 and the E-Verify processes. So unless we're talking about maybe an E-Verify Plus where you've got kind of an automated system, and some employers, larger employers particularly, you might have a PEO, or you might have an organization that does your workforce things where they kind of combine all of the services for you. You've got an E-Verify provider and an I-9 provider. But other than that, genuinely, if you're an E-Verify employer and then you're filling out both the I-9s and the E-Verify. So it's kind of a double trouble where, even though I-9 is part of the law, you're required to do it. But if you're an optional E-Verify employer, well, you're also adding on the responsibility of doing this separate process and making sure you carry out both properly. And the final con really is, to a certain extent, it's a con with the I-9s as well, but you have to collect and store, sensitive employee information. And so that's another layer of risk, in the sense that, well, if there's ever a leak or anything like that, or you're retaining copies on your computer, things like that, it's sensitive information, and it's subject to some risk as well.
So another thing to be mindful of, some errors that common errors that you might see is if, like you mentioned earlier about an employee that just got married and has, a hyphen or a misspelled name, those might be triggers as well.
Those might be examples of situations where you're going to get a false negative, what we'd call it, where they give you a negative result, but really there's a pretty valid explanation for why that situation occurred.
Right. And so one thing that we love to do as well is give everyone checklists, right? Because we know how busy you all are, and one sheeter can really be helpful when you are going through all of this and trying to be proactive. And so we compiled, those steps. Everything that we spoke about throughout this masterclass is, that checklist, completing section 1, who completes it, when, what is the deadline, all the way down to using the E-Verify. Again, that is to your discretion if you are not part of a mandated state. And so the cool thing too about being a member of the Culinary Business Network, all these templates are going to be on the network. And shifting gears as well, and we also have another template, which actually we're going to kind of dive into right now, because as you all know, they may or may not show up, right? And what do you do when they show up? So let's talk a little bit about that moment. No one wants to imagine it, but everyone needs to plan for it. So Saif, tell us, if ICE shows up at the workplace, what notice of inspection or warrant, or what should we be looking out for? What are some of those immediate steps that employers can take
Right. And
in preparation of something like this?
right. And that's such an important topic. I mean, it's a stressful time if ICE shows up to your door. And the most important thing is to always have a plan, right? Because plans give you a sense of calm, they give you a sense of purpose, and you know what steps you need to take to deal with the situation. So I'm actually going to rewind a bit. I'll tell you about a step that you should take before ICE even shows up, and that's the I-9 audit. And that's when I say I-9 audit, I'm talking about an internal audit. This is you double checking your systems, double checking your I-9s, making sure everything is done. You've crossed your T's and dotted your I's. And
Absolutely.
This is something that, Counsel, Labor and Employment and Immigration Counsel attorneys, we help clients with this all the time. And so if you have a trusted attorney, you have a trusted legal team, please make sure that you're conducting these I-9s on a regular basis, because that's a proactive step you can take. So we'll talk a little bit about what we're going to do if ICE actually shows up, but this is actually one of the number one things you can do, and it's before ICE shows up. And so making sure you're internally auditing your systems and making sure everything is shipshape, that's a great first step to take before ICE even shows up. But now let's say we're past that, ICE is at the door. What are we doing? Number one, always having a plan, right? The first thing that we should always do is, if you have an attorney or you have legal counsel, notify them immediately, and always have a designated manager to deal with ICE agents at once, because you don't want to leave it in the hands of, if maybe you've got a front of staff or a front of house, employee, maybe they're 18 or 19 years old, young, and they're terrified when an ICE agent shows up and starts flashing badges and providing documents, It's a good idea to have somebody that's trained, and that's somebody that's been run through the procedures, so that way they know how to deal with ICE and how to carry out this plan that you've set in place when ICE shows up at your door. So it's important to, again, we talked a little bit about, I-9 audits, internal policies, but training is one of the most important things you can do. And it's often easier to train that one manager than it is you should train your whole team, but having that one designated point of response really gives you kind of a cohesive response, and it gives you one person who can be in charge of the situation and delegate and deal with things as needed. It's always a good idea to be calm and professional when you're dealing with government agents. So that's something, when you have a designated manager, to incorporate into their training. Your designated manager should always be requesting verification of the identity of the agents, which agency they're from. So we say ICE, but sometimes there's corollary agencies that will pull up. Homeland Security Investigations, HSI is one of them. So, but you always want to make sure that it's a designated government, agency, and I hate to say it, that sometimes there are ICE impersonators out there.
Right.
I haven't heard of a situation where they've come up to a restaurant, but there have been situations where ICE agents have tried to detain people. And so again, it's always good to get verification that the agents are from ICE. Now, your manager kind of needs to triage the situation and see what they're dealing with. So ICE doesn't always, and we sometimes we talk about ICE raids, right? We say ICE raided this workplace, ICE raided that workplace, but ICE doesn't always raid workplaces. That's really kind of a drastic step of action. Their first line of investigation is what we call a notice of inspection. And that it won't look like a raid, because there won't be ICE agents, coming in with, there won't be like 20 ICE agents coming to your restaurant and they might be armed, they might look scary. That's not what a notice of inspection looks like. It might be as simple as the ICE agent coming to your door, speaking with your manager, telling you that they're starting an investigation, and serving you with a notice of inspection. So if they're inspecting, they start a notice of inspection, they're basically inspecting whether you're following the law, whether you're complying with the I-9 regulations. And NOIs have procedures and tight deadlines. So when they provide you with the notice, it's going to tell you exactly what deadlines you're dealing with. Typically, you're provided 3 days to respond to an NOI. So what your designated manager needs to be trained to do is, if you're served with an...
Can you say that again? I'm sorry. NOI, what? Notice?
Notice of inspection.
Got it.
Sorry, yeah. I think I rushed to that, but NOIs are notice of
okay.
inspection. Yeah, and like I said, the notice will have procedures and it'll give you deadlines by which you need to respond. So your manager needs to kind of, when the ICE action starts, they need to know if they're dealing with the notice of inspection. I've got to notify my legal team, my HR, and get legal counsel involved so that we can start responding to this, because we're on a deadline, we're on a clock. We've got typically 72 hours to respond, and that's where the attorneys.
So you have 72 hours to respond to an NOI.
Typically, yeah. So the NOI will provide you with the deadlines that you need to comply with. It's typically 72 hours, 3 days.
3 days. Okay. Then there's also, and we have to break this down, because there is a huge difference between There's a big difference, right, between a judicial warrant and an administrative warrant. And the administrative warrant is not an NOI, correct?
Yeah, an administrative, an NOI itself is kind of an administrative document. When we talk about warrants, they typically come in 2 different varieties. One is an administrative warrant. So for example, if ICE itself or some kind of agency issues a warrant for, maybe, and ICE does this, they have warrants for arrest of what they call arrest of aliens. So they're really looking for a targeted individual. That's not a judicial warrant. Judicial, the name is kind of a hint. A judicial warrant is a warrant that's signed by a judge. And so when we're talking about, well, when you're complying with ICE, one of the key things to know is what kind of warrant you're facing. And when you're facing a warrant, is it a federal judicial warrant, or is it a judicial warrant signed by a judge? So as you can see in this example, it's got a court name. It says United States District Court. And at the very bottom, it's going to have a judge's name and signature. That's different from, if you look at the other example, it says U.S., I think it says U.S. Department of
Homeland Security.
Homeland Security. So Department of Homeland Security is not a court. Homeland Security is an agency. And so what they issue is they can issue administrative warrants. But if you look at the very bottom, it's got this signature of authorized immigration officer. Well, an authorized immigration officer is not a judge.
Not a judge.
So if you're ever faced with that and your manager gets presented with a warrant, if you've got legal on the line, it's a great idea to take a picture, send it to your attorney, or call your attorney and say, hey, I've got this warrant. Is this something that is this a judicial warrant? Do I have to let ICE in and search, my premises? Or is this an administrative warrant and where they're limited to they might be allowed to roam public areas, but they're not allowed to go into your private areas?
And speaking of that, one thing that I do want to stress is empowering not only yourself as a business owner, but your supervisors, your managers. Don't panic. Have a plan. That's what we're here to do. That mindset is everything. Conducting some of these like fire drills, right? Like mock scenarios, to also have your team really comfortable with something like this. We also have, you brought up something as well. There's tons of organizations right now kind of helping, differentiate between private spaces and, where the public can be. Now, as we're navigating this, we have had feedback of business owners where it depends on the agent and if they respect those spaces or not. And so as small business owners, how can we kind of, I don't want to say stand our ground, but really be proactive in, is it putting up these signs, or is it making sure that our managers are empowered to say, hey, you cannot go past this because it is a private space? Is that something that you all recommend?
Yeah. And so, for example, the signage that you have up there clearly delineating what are private spaces. Now, of course, not everything can be a private space, right? We have to kind of, if it's not obviously a private space, than just putting a private space sign on your restaurant floor where your patrons come and sit. That doesn't convert it into a private space, because generally that's open to the public to come in and sit. But if you're clearly designating the back of your kitchen, your storage space, your storage facilities, your administrative offices, anything like that, that signage is typically that's a good idea to put it up there, because you're documenting and you're putting the ICE agent on notice that this is a private space for employees only. And without a judicial warrant, they are not supposed to be able to enter those spaces. Now, if they have a judicial warrant and you verify with legal that it's a judicial warrant, then you need to comply with the orders of that warrant. So if they've gotten a warrant signed by a judge to come and search and search the place, then you have to comply with the warrant. But if they have just an administrative warrant, then they're not able to use those to come into your private space. So as a business owner, what you can do to protect yourself is, when you delineate those spaces, you can document any overreaches of power. That, of course, we never say stand your ground in the sense that physical altercations, all of that can lead to negative results. But documenting any overreaches, maybe if officer doesn't have the correct warrant and they enter a private space, you can protect yourself by having those delineations, having records of those overreaches, and then you can pursue relief in court, or through any other legal avenues of pursuing relief. But by protecting yourself, by setting these limits, by designating private spaces, by examining the warrants and complying with the warrants that you need to comply with, which are the judicial warrants, and not complying to the permit of the law, that a administrative warrant doesn't allow an ICE agent to come in and ransack your office, your private office. Knowing those limits and what you have to comply with and what you don't is very important. And one other thing I do want to touch on is really important. If you are faced with ICE action, please do not attempt to conceal or mislead or hide anything. I know that there's always a temptation. We want to protect our employees, but misleading information or concealing employees can lead to severe criminal charges. So, again, please make sure that, you stay within the bounds of your rights and the law when dealing with ICE action, because you don't want to end up in criminal trouble. That's the last thing we want.
Absolutely. And speaking of how to support employees, we do have some more resources as well on knowing your rights. Again, the staying calm, the know, which parts, they can and cannot go into, making sure that you do recognize the difference between a judicial warrant and an administrative, contacting a lawyer. We have, you have at your fingertips, literally, Monty and Ramirez, their law firm, and then just continuing to staying up to date to any of those changes. We have a ton of resources for you all as well. Not only this one, but we also have employer rights and responsibilities from the American Immigration Council, and then we also have some more tips in terms of how do you, as a business owner, also protect your employees, right? Supporting your employees and protecting that workplace is also important. It's not just paperwork, it impacts people. It impacts maybe some of your own staff. We have had some business owners who have drastically been affected employee-wise from these situations. And so how can business owners support staff? Can you walk us through, again, Monty and Ramirez have a slew of programs as well, which we will also be providing you all. But talk to us a little bit about some of the programs that you all have for employees. As we talked about the services that you all can offer employers, but tell us about how we can support even just our employees.
Right. So, I don't want to limit it to employees, because the plan Prepárate is something that we offer. It's for anybody that's undocumented. And so one thing I did want to mention is that, of course, if you have, it's always a bit of a fine line, because if you have employees that are undocumented, by law, you're required to terminate them. Right. But it's at this time, it's important for anyone that is undocumented to know their rights and to know what their rights are under the Constitution, what their rights are under the laws of the United States, and what they can and cannot do if they, as a private individual, are facing action. One of the products that we offer at our firm to anyone that's undocumented is the Plan Prepárate. And what the Plan Prepárate is essentially is an immigration defense strategy. So for one annual fee, we open a file for an individual that's undocumented, and we provide them with a letter of representation. We consult with them to establish an immigration defense strategy. If anything should happen, if they're taken into ICE custody, then we have a legal strategy set out for them. And then essentially what it does is the advantage that the Plan Prepárate offers you is that you've got immediate legal assistance at your fingertips. Mm-hmm. If you need us to file a motion, a bond motion, for example, if you're in ICE custody, or to work on some kind of relief from removal or deportation, then the Plan Prepárate gives you the launching pad. We've got your file at the office. We know your immigration history. We know the strategy that we want to pursue, and it saves you that time up front, because what you don't have to do is talk about all of this with an immigration attorney while you or a loved one is in ICE detention. Mm-hmm. Instead, you've got an attorney that knows all the facts, and you just say, hey, what we need is a bond motion, or what we need is a cancellation or removal, or whatever the strategy might be that we've discussed with you in advance. Then we can start that process and do that for you. So what the annual fee gives you is that it gives you this legal strategy, and that if you need to hire for a motion, a bond motion, or for any other kind of removal, we know the facts of your case. We have the strategy pre-planned for you, and that you're not scrambling to find an attorney at the last minute, really when time is precious and a loved one is in immigration custody. And in general, some of the items that we've provided, again, for not necessarily just for employees, but just for people in general, is to know your rights at the workplace. If ICE shows up, to know your rights as an individual if you're undocumented. I think, Karina, we've got some resources for you guys that talk about things, if you're pulled over, what are your rights if you're speaking to a police officer? What are your rights if you're speaking to an ICE officer? Those things, I think, on an individual basis are really helpful for anybody that's viewing this program. And so that way, you can be informed with what your rights are and what you are afforded within the law.
Absolutely. And, our job at the foundation is to continue to provide those resources, because I get a lot of times, you don't know what you don't know. Mm-hmm. And you try to look for, or you hear things here and there, but never, access to information or even, templates or who to go to. So I am so grateful that, we get to partner with, individuals like you all to be able to provide not only the knowledge and the skills and the know-how, but also, those tangible resources that we literally walked everyone through step by step, everything from an I-9 to, E-Verify, and now even what to do, because these are really telling times. And so thank you again for sticking through with us as we navigate these new waters. And then how do in terms of how do people get in contact with you? I think I had it on here, with you all, if they want to set up, I know there's a phone number. Is there, say they're in the middle of, I think I had it. Say they're in the middle of an ICE audit or raid. Can they reach out to you all if they are in, let's say, in California or in New York, right? I think I want to make this clear too, that just because they're in a different state, they can still reach out to you all.
Right, that's correct.
So can you talk a little bit about that?
Sure. Because
it's federal and not like I can
right.
hire you all, or I can call you immediately if I need you. all because I heard this, or,
Right. So immigration law and I-9 is part of the immigration law. It's a federal, it's federal enforcement. So of course, if you'd like to have an attorney that's nearby in your hometown or your home state, and you'd like to go through with them, that's completely, I think, perfect and something that you can do. But any law firm, including ours, that is practices immigration, and because it's a federal practice, we don't have to be in your state. We can represent you from. We're based in Houston, Texas, and we can represent you.
Right. Thank you. That's my point, because we were like, a lot of small business owners might not have access to a local attorney and don't know where to look, and so the fact that they're able to hear it from you, I think, is really good to know. So again, thank you so much for your insight. And, a quick recap, what we just talked about was ensuring that every employee has an I-9, and that you as an employee can fill those out with confidence and do it properly. We've considered even doing mock ICE drills, what to do if you do get a visit from ICE, and then also, looking at E-Verify. And again, always stay calm, know your rights. We're giving you those resources. Don't act alone if that enforcement does happen. So you'll find all of this again in the resource library as a member. Again, if you're not a member, for less than $1 a day, you can become a member of the Culinary Business Network. And I was going to show the membership platform, and I think I deleted it. It's okay. I think I deleted it, the little video. It's okay. So just there's so many little tabs open. Again, printable spreadsheets and templates will be available to our members on the Business Resource Library. We'd love to hear from you. Drop your questions in the chat, raise your hand. We can, have Saif reply to you all if you guys have questions, and you guys can obviously also reach out to them as a resource. So thank you again, Saif, for sharing not just, information, but a sense of clarity and control in an area that can feel very much so overwhelming. And to everyone here, the best way to protect yourself and your business is to be proactive. And your time today is a powerful investment into your people, and hopefully we can give you that peace of mind. And if, again, you haven't become a member, go ahead and check us out on our website. Our learning library is available as well. And remember, you don't have to do business alone, and you're not alone in this journey. And when you thrive, we all thrive. So see you all next time. Thank you so much, Saif.
Thank you for having me. Happy to help.
Yes, thank you so much.